And Kunbi, just to sort of our guest on the call, just to let them know that one of the reasons why I'm here is that I'll be chipping in with practical examples, and I'll be using Serbia as that example. So hopefully it won't be death by PowerPoint. We've only got 13-14, so it's not a long session. But by all means, and I also in the chat box will be sending you some links to some useful websites and some useful advice, signposting you to where you can find out information that we talk about during the presentation and during the webinar.
Thank you very much, Nigel. And if you have any questions, please, you can put them in the chat as well, so we can begin to consider them as appropriate in the course of the session. So the first thing is to determine what exactly constitutes a transfer. The name is sort of a misnomer. It implies, in the ordinary sense that you are, moving this data, perhaps not physically, but, you're moving this personal data from one location to another. In reality, as per the definition of the GDPR in Article 44, it's not a requirement that the data is actually transmitted. So transmission of the data is one, condition that would trigger the, provisions with regard to international transfers, but merely giving access to that data to an organization or a person who is in a third country also qualifies as a transfer for the purpose of the UK GDPR. So that implies things like...
And Kunbi, a great example of that would be that when I talk about my Serbia project, it was the developers of the software were based in Serbia. No data was actually being transferred from the European and UK operation, but they were redesigning and playing with the software application and also the databases, which were based in the European Union and the UK. So they were actually not transferring it, but they had the ability to access it from Serbia because they were doing application development on behalf of the client.
Exactly, thank you. So that's an example, a perfect example of where the UK GDPR's provisions with regard to transfers would be triggered despite the fact that the data is not being, actually transmitted to a third country. So the next thing is, as background as well, what the transfer mechanisms are under the GDPR that organizations can utilize to transfer personal data. So the first one is, transfers on the basis of an adequacy decision. So if an adequacy decision exists for the country to which you intend to transfer personal data, then you can do that without any restrictions. You do not need to proceed with conducting a transfer risk assessment. Article 46 is transfers that are subject to appropriate safeguards. Article 47 is for binding corporate rules, and Article 48 and Article 49, do what they say in terms of transfers not authorized and derogations for specific situations, such as when a person's life is in danger and you have to make, an emergency transfer to help save their lives. The next thing is the appropriate safeguards. This is where transfer risk assessments are most important. This is because this would be the bulk of the transfers that an organization takes, performs if it's going to be going to a third country. Now, under this, we have, legally binding and enforceable instruments between public authorities. If you are an NHS trust, for instance, the possibility exists, subject to approval by the ICO, that, a legally binding and enforceable agreement can be entered with a comparable organization in the public sector in a third country that, subject to the permission of the ICO, will then permit, with certain restrictions, transfers of personal data. So there's binding corporate rules, the standard data protection clauses, which as of today, you are only able to use either the UK's IDTAs, that's the International Data Transfer Agreement, or the new UK SECs with the annex to them, with the UK annex to them. Now, you also can utilize an approved code of conduct, although at this point in time, we do not have anyone available, as well as an approved certification mechanism with the same issue, essentially. Now, what is let me sort of at the end of each slide, I'll let you do the slide, and then at the end of each slide, I'll just make a couple of comments there. So what it might be useful is asking the audience just to consider for maybe 20 seconds. Are there any countries that they transfer
personal data to, and that's the key, personal data to. That's the key, not information, personal data to, or allow people to have access from which meet this criteria. So it's well worthwhile just considering now and just writing down if you're, very important point really, that if you're sitting in your office or sitting at home at the moment thinking, do we do any of this stuff? I've sent you a list of the adequate countries. So we're talking the 27 countries of the European Union. We're talking the 14 countries on that list. And if they don't have Korea on that list, South Korea, that's now on the UK list. And if they don't, if you transfer beyond that, then therefore everyone's in scope. And I'm making, big ones, USA, a good example, South Africa, a good example, India, a good example, China, Russia, another big example, and even smaller countries that might not, Ecuador and Peru and countries which we might not consider. So it's well worthwhile considering those arrangements that you might have in place. On this list that Kunbi's got in front of you, it is unlikely that unless you are a very large organization which has spent a lot of money and spent a lot of time and have approval from the Information Commission to have binding corporate rules. As Kunbi quite rightly said, there are no real code of conducts and there are no certification mechanisms yet for transferring personal data. So the vast majority of you will be using the standard data protection clauses, which if you are based in the European Union, you'll be using the European Union ones, or if you're based in the UK, you'll be using the standard contractual clauses, which the UK Information Commission has issued as a template, and I believe they're the ones to follow as such. So really, we're talking about actually that the appropriate safeguards, unless you're transferring to the European Union and adequate country, are really going to be standard data protection clauses, and also you're going to have to need a transfer risk assessment, and hence our conversation. Louis, all yours.
Thank you, Nigel. So there are two things essentially that the law and the guidance from the ICO, and depending, like Nigel said, on where your organization's operations cover, if you operate in parts of the EU where supervisory authorities in those territories have said organizations must focus on when conducting a transfer risk assessment. Now, the first one is the risks that such a transfer could pose to people's rights. And the second one is the risks that could arise from difficulties with enforcing the transfer mechanism that your organization has chosen, which, as Nigel has said, for the vast majority of people and organizations will be the standard data protection clauses. So this is, an overview, is something to bear in mind in the course of the assessment, because it must reflect throughout your evaluation as well as in your conclusion as to, we have determined that X transfer will have no low, medium, high impact on people's rights in, Y country. And we have also assessed and determined that there will be, no low, medium, high difficulty with enforcing the data protection clauses that we have, agreed with the data importer. Nigel, please.
Yeah, I thought I'd raise my hand. It's probably a better way of getting my 2 pennies worth in. Sorry, Kunbi. So Kunbi, when it says risk to people's rights, what does that actually mean? What tangible can we attach to that term, risk to people's rights?
Thank you. So if some of the biggest developments in the area of international data transfers are, the Schrems 1, Schrems 2 cases that, the European Court of Justice ruled upon, which then determined that previous frameworks that had been put in place for transfers to the United States specifically were inadequate. Now, the focus of those judgments was specifically in the area of surveillance. So, to answer that question, one of the biggest risks is that people's privacy can be infringed. So privacy and data protection are two, similar but distinct things. But in this context, the right you are trying to protect the most is going to be the right to privacy. However, bear in mind that the right to privacy often connects with other essential rights. So when people's privacy is breached, the potential exists that, other rights of theirs could also be breached. Their, even their right to life, their right to, healthy living could be breached if the information about their location, about their daily activities, where they work is, leaked or breached to people to whom it ought not to be. So privacy, yes, directly, that's the question. That's the answer, privacy, as well as potentially other rights. Nigel, please.
Yeah. So Kunbi, but the answer you've just given then sounds like really like if you're sending personal data to a country where, for example, someone will have a back door to be able to search around, that might be the state, and in case of the Schrems, wasn't it? The Schrems case, it was about the National Security Agency could, if they wish, view information or personal data that was sent to the USA. In simple terms, it was more complex than that, but in simple terms, that if you're sending personal data to a country which snoops around the back and has a back door into, then therefore you might need to undertake a risk assessment and therefore put in extra safeguards to prevent that personal data being snooped on by those who have powers in that country to look at that data or use that data for, as you say, different purposes.
Yeah, that's exactly correct. And like Nigel has said, it's going to be, we have an entire slide on things to consider when evaluating the similarities and differences between the UK's legal environment as well as the legal environment in your, the country to which you are transferring the personal data. So here we have a table essentially showing two, core points that the ICO in the UK as well as the EDPB in the EU have identified as being the focus of the data protection transfer risk assessment, essentially. Now, the ICO in the UK has said that it's comfortable with organizations using either one of these methods. And what we've done here is put them in a table to show you, how they differ. But the ultimate lesson here is that in essence, they want you to do the same thing, which is to assess the risks that we have identified in the previous slide, which is the risk and potential risk to people's rights, as well as the risks in terms of difficulties enforcing the data protection clauses. Now, there's no need to go over all of this, individually, but the key things that are similar between them are that you are required to have a granular, assessment of the transfer you are intending to make, which would cover, what data is to be transferred, whose data it is, where it's being transferred to, what organizations are to be given access. You're also required to assess the country to which you're transferring that data to determine if it's a safe country for people's personal data, as well as to conduct regular evaluations on an ongoing basis. So, Nigel, do you want to speak on this?
Yeah, no, that's a really good point. Now, I've just written a couple of notes actually. So could you put the slide back up, Kunbi? Just put the slide back up again. So what we're doing here with the transfer risk assessment is we're assessing the country. So what I'm deducing from this is in your standard contractual clauses in Annex 2. So for those people who are familiar with that, Annex 2 is in essence the specification that you will put on your data processor or the person that is either accessing or processing personal data in the third country is a list of security arrangements that you would like to put in place. So those would be who access controls, malware and antivirus security arrangements, who can see the data, VPN, secure links, firewalls, etc. That would sit. All the security stuff would sit in the standard contractual clauses. What you're doing in the transfer risk assessment is transfer risk impact assessment is assessing the risks to the data subjects solely based upon the type of data that you're processing. So, for example, a name and an email address necessarily will require lesser safeguards, for example, than if you're transferring special characteristic data. So you're assessing the country of destination or access based upon the nature of the type of personal data you're transferring, and their ability to access, interfere it, use it for other purposes.
Thank you, Nigel. That's exactly correct. So the ICO tool, we have a link to the ICO tool, and we have a slide about that contains resources, right? And one of those resources is the ICO tool. And the ICO tool is what the ICO's version of, attempting to make the process as simple and straightforward for organizations as possible. And the ICO itself, however, qualifies the circumstances in which that tool would be appropriate. So in the ICO's guidance, again, which we have a link to in the resources slide, which we're happy to share after the webinar, it says that you cannot use that tool if obviously if the transfer is to a country that is covered by the UK adequacy, determination, which means essentially you are not required to perform a risk assessment. However, if you're
if I'm sending information, personal data to any one of those 15 countries,
yes,
no requirement to do a transfer. It's already been assessed, because the adequacy arrangement follows very similar assessment of the country of destinations based upon the similar tests. Yeah, I get it. Thanks, Kunbi. Yeah.
Yes, you are also not required to use it or perform any risk assessment, generally speaking, if you are relying on an exception, one of them being one of the derogations, which we covered at the beginning of the session, which would be in relation, for instance, to a person's vital interest. So if a person is having a medical emergency and it's vitally, it's crucial, a matter of life and death, that their personal data be shared in order to save their lives, then you can do that and proceed with that without needing to perform a TRA. Now, the third one is the most important and the most, applicable to most organizations here, because it references the possibility that a proposed transfer, which is referred to here as a restricted transfer, could be too complex for the tool to be applicable. So if you've taken a look at the ICO tool, it's essentially, a Word document that's, you select yes or no, or select 1 or 2 or 3, and so on and so forth. It's quite, basic by design. Therefore, it would not be possible to use that where the transfer is too complex. For instance, where you are going to be transferring data that is intended to be transferred onward from the importing country. You are going to be transferring data that would require a DPIA by virtue of the fact that it's going to be using new technologies or processes. For instance, if you're signing up to a new robotic process automation system for your organization, for instance, to process, patients or customers or some other sort of service, then that tool would not be ideal for that purpose. You would be required to perform a full assessment using the ADP-based methods. So the third one is where the country itself has a bad human rights record or other legal concerns that make it so that it's important to perform a more exhaustive risk assessment. Nigel, do you want to add to that?
No, I'm what I've done in the chat box is I posted a list of the UK position on adequacy for countries as well. So that's in the chat box, Kunbi. So we're definitely okay. We're definitely okay with that. So when I consider my Serbia example, so I'm trying to tick off all the boxes as you go through the slides here. My Serbia is that, are you transferring special characteristic data? Answer no. I'm transferring but credit card information, bank details, yes. So it's fairly medium risk information, or not transferring, but they have access to. They're outside the European Union. They don't appear on any of my lists. They do not appear on the UK list. When I cross-reference them against the EU list, Serbia doesn't qualify in that list either. So they're an inadequate country. We have a standard contractual clauses. We have no other transfer mechanism apart from that. So in essence, my client was looking at having to do a transfer impact assessment. So having got to this slide now, I'm still of the opinion that we're absolutely right to do it. Yeah.
Thank you. So before performing a transfer risk assessment, the previous slide, we touched on the circumstances in which you would not be required to perform a transfer risk assessment. If you've determined that you are required to perform one, what then are the prerequisites for, performing such an assessment? Now, the importance of this is that your transfer risk assessment, by definition, serves as a supplementary measure to the appropriate safeguard that you have determined that is best appropriate for your proposed transfer, which, as Nigel said, would typically be standard data protection clauses. So having determined that the best transfer mechanism is the standard data protection clauses, you are performing the risk assessment in order to be able to show that you evaluated the options properly before deciding to choose that transfer mechanism, as well as choosing to proceed with the transfer itself. To be able to show that you have gone through that process lawfully, it's important first that you determine if you are using the minimal amount of data. And this is key because, as we just put there, is less data equals less risk. The more data you have in your custody, the more data you are transferring to a third party, the more data you're transferring to a third country, the more the risk coverage area, so to speak, the higher the likelihood that something could go wrong. So as general best practice, when we at DPAS work with clients, we generally begin from the perspective of minimizing the risk internally first before we begin to interact with externalities, such as risks because of the organization to which the data is being transferred, or risks because of the country to which the data is being transferred. So it's important, Article 25, with regard to and onward, with regard to privacy by design, talking about minimizing the data you collect, minimizing the data you process in order to be able to reduce the level of risk. So security is the next one. Do you have adequate security measures in place? We're going to discuss this more in depth, but as a basic level, before you begin to contemplate transferring data, you must establish that the organization to which you are transferring that data has the capability to provide adequate security measures. So that's where what Nigel said earlier about having proper cybersecurity measures in place becomes very crucial. And this, of course, must be commensurate with the kinds of data you are transferring. The third one is lawful basis. So obviously, if you have a functioning RUPA, which is a record of processing activities, you have an inventory of your data, you should be able to assess and determine what your lawful basis is for processing that data, because that's going to be an essential component of the risk assessment. The fourth one is with regard to the processor. Are you going to have a proper data processing agreement with them that then binds them to a series of standards in how they process that personal data? That's crucial because as controller, you have the ultimate responsibility for whatever happens with that data, and it's important to be able to show and bind your processor to upholding the same standards. And lastly, if I just ask Nigel to chip in, it's with regard to transparency. This is extremely important. So if you've looked at the ICO's website for their penalties, their decision notices, their penalty notices that they've issued to companies recently, a lot of it has been in relation to the lack of transparency, organizations collecting data for one purpose and saying they're going to use it in the UK for X purpose, and then determining that they would like to repurpose that data or share it with one service or another for whatever purpose. So it's important that your privacy notices be clear and transparent with data subjects as to where the data will be going and for what purpose. Nigel?
Yeah, this is a really good slide, Kunbi. Thank you very much. So if I go through my Serbia example with this, so predominantly the fact is that they were developers. So they were developers who were developing the software package of which the UK and EU clients, same client, but they had numerous bases in UK and EU, same software. And of course, they were developing the software, but also needed to have access to the keys to every door. So clearly that's a bigger risk if they were than if, for example, they were only working on a small section of the application, which didn't have access to everyone's personal data. So clearly, the more data you have, for example, where they have the keys to all the systems, the keys to all the database, the keys to all the software, then clearly that's a bigger risk, for example, than your data processor who's based in the third country only having access to the minimal amount of data they need to achieve the task. In my client's case, it was they needed access to everything to be able to undertake the activity. So that was a bigger risk. Security arrangements, as I touched on earlier, in Annex 2 of the data processing, of the standard contractual clauses, that's where you specify exactly what level of security you would expect as a minimum. And Kunbi's, I know, has got a slide on that later, and an example that we've done and we're happy to share with you. And the lawful basis as well is about that once we've defined it. So we're going through a tick list here, aren't we? Is there a lawful basis for that to happen? And clearly, I told you earlier that we had a contract in place, standard contractual clauses anyway. One question I've got for you, Kunbi, on transparency. And transparency, for those people who are not quite sure, means that at the first point of data collection or at the earliest opportunity, you should make available to data subjects the opportunity to view how the controller processes your personal data and where it's shared and where it's processed by other organizations, third parties, processors, and shared and processed and accessed offshore. That's where you should put in it. What if you are considering, at what point, say for example, you are bringing on a new processor, which is you're based in Scarborough in the UK, and you are giving access to a new, let's say Bangladesh, for example, a new Bangladesh a company which is going to enable some of your software, but needs access to the database. At what point do you publish your privacy information because you're just thinking about it? Do you then retrospectively, once you've signed up, for example, the Bangladesh processor, do you then contact your data subjects to say, actually, we're bringing on a new processor, this is where we're doing, and here's the new privacy notice going to be? Is that the point of which you then display the transparency? Because a lot of these activities will be taking place when you're bringing on new processors rather than existing ones, because one would suspect that we're now 6 years into GDPR, and if you haven't got them listed in your privacy notice, then you've been non-compliant for 6 years.
Yes, Nigel, I think, you used the perfect phrase, as early as possible, right? The GDPR recognizes that organizations and their plans, the projects can change over time. So obviously there's no expectation that as a privacy leader in an organization, you have a crystal ball with which you can predict what management is going to do, and then, draft a, forward-looking, privacy notice as such. But what is important is that as early as possible in the, and that's where privacy by design and default again comes in, as privacy leaders being integrated into your organization's operations, such that you're able to bring in privacy expertise very early on in any product or service development process. But to answer that question, so the first thing is, as soon as possible, you need to update your privacy notice with the new information as to what you intend to do with that data, where you intend to transfer it to, as well as notifying data subjects actively. So it's absolutely best practice to send an email or send some other notification to say, hi there, we've updated our privacy notice, we've updated our data processing terms, and we would like you to take a look to be aware. And that doesn't necessarily mean that the person must consent in order for you to be able to continue processing that data, because if your lawful basis for processing, for instance, is legitimate interest, and that lawful basis permits you, after assessing, of course, permits you to continue transferring that data abroad, you can still go ahead. It's not as if you require people to opt in afresh. However, you do need to provide people with up-to-date information, provide them with comprehensive information, such that if they want to object to your processing, for instance, they have the ability to do so, in accordance with the law.
Thank you.
Yes. So here we're just going to begin, the actual, I have now determined that I need to do a TRA I have now determined that, that TRA is necessary because, none of the exceptions apply to me. I've now determined that we have met all the prerequisites for doing a TRA, which is we've minimized the data, we've, had a processor contract and agreement in place with, we have the capability to implement adequate security measures and so on and so forth, like we covered. And now we want to actually begin doing and performing the TRA. So the first thing you must consider, if you remember our slides comparing the, UK ICO method with the EU EDPB method, is what personal data is to be transferred. That's the first and most important question, because that personal data will determine everything else, both in terms of the security you need to provide for that data, as well as, what your lawful basis might be for processing it and all the other consideration. So here we have, this is a sample. Bear in mind, this is an extract from the UK ICO's guidance, but they say, and we are saying for emphasis, that it is intended only as an example, as a guide in abstract. It's not intended to be, dragged and dropped into a, transfer risk assessment, because as Nigel said, it's heavily dependent on context, right? So a person's name might ordinarily be, low, risk data. But if the person was, a security official working for MI5 or MI6, for instance, then their name, drastically changes in its significance from a low risk item to something that is extremely high risk, and that could immediately upon sharing put their lives at risk. So clearly, this is just an abstraction for you to use in, preparing a similar table for your organization and your operations. Nigel, I know you have thoughts on, personal data.
Yeah, no, and Mel's just asked a question, funny enough, which is very timely. Look, can we use the same transfer risk assessment each time? It depends. No is the answer, because it depends on what type of personal data you're transferring. The risk will be higher depending, or lower, depending upon the type. So, for example, if you're low risk data, low risk personal data, then actually you make the risk assessment based upon that. Yeah, the government of Serbia, and they don't, by the way, have a look around and can have access to the systems that organizations have access to in Serbia online. But it's only low risk data, then you might say that's absolutely fine. However, if Serbia, for example, let's say, for example, Kunbi, Serbia, for example, had very strong LGBTQ plus laws, discriminated individuals from those people, from those groups, then therefore, if you were transferring, for example, that sort of data, a quality type data, to a country where had access to the back door, was able to look at that information, you might think twice about, for example, your transfer risk assessment and the extra safeguards you want in place. So Mel, the answer to your question is, depends upon the type of personal data that you are sending and the safeguards that you have got in place with the processor or the person who accesses that data in the state. It absolutely depends. So, for example, the Serbian one, yes, a lot of the template will remain the same. But of course, the other thing you need to remember is that laws change all the time. So laws change all the time. So if you do, for example, myself and Kunbi had a conversation about the election in Nigeria. There's a new government in Nigeria. The law might change in Nigeria in 6 to 7, 8 months' time. So we might have done, for example, a transfer risk assessment for transferring personal data to Nigeria last week. But in 6 to 7 months' time, that may not be valid, dependent upon the laws and the regime that's in place in Nigeria in 6 to 7 months' time.
Thank you. And I think that's a perfect answer. I would just like to add that the organization to which you're transferring that data is also, in many cases, extremely important. And as an example, recently at DPAS, we performed transfer risk assessment for an organization intending to transfer personal data to a third country. And one of the factors there was the organization, a major global technology behemoth of a company, had already put in measures in place where they had stated very explicitly how they would combat, any attempt by government officials in their countries of operation to access data, right? So they had talked about how they would be, going to court and challenging those court orders and so on and so forth. So if you're transferring personal data to such an organization, by necessity, there's a difference in the amount of risk to that personal data, as opposed to if you're transferring it to a very small organization, if you're just transferring it to your web developer in India, for instance, it has a significantly different ability to stand in opposition to the government to restrict or resist any attempt to access that data unlawfully. But what if you're transferring the data to a government agency abroad, where there's a clear path for the government to access that data at will? Naturally, there's a difference in the amount of risk to that personal data. So that's also something to bear in mind, which is to answer Mel's question. Another reason why it's not practical to utilize, the same risk assessment over and over again. So very quickly, and we've touched on this already, so it's going to be brief. It's in addition to what personal data you're transferring, the persons whose personal data you're transferring is an important consideration. If they are minors, then the UK's GDPR and Data Protection Act laws with regard to the personal data of minors comes into play, in the EU as well. If they're vulnerable adults, then their ability to consent to your processing of their personal data becomes in question. So then you have to make extra effort to be definite about your lawful basis, as well as make extra effort to protect their personal data because of the increased risk to them if there is a breach, like we outlined earlier. Do you want to touch on this, Nigel, or next slide?
No, next slide. We're fine. Yeah.
Okay. So this is perhaps the biggest aspect of your assessment. It's your determination of whether or not the importing country has substantially similar data protection laws to the UK or the EU, depending on where you're transferring that personal data from. Because the entire purpose of the risk assessment is to determine whether the personal data will be an increased, risk of unlawful access or unlawful interference in that foreign country. So we have a list of factors to consider here that you can essentially, use as headings, perhaps, and just use to be able to draw inferences about the country. So you have whether or not they have a law like the UK GDPR, whether or not they have laws regulating biometrics and facial recognition or CCTV, how easy is it for, the police or judicial authorities to, surveil people, and surveillance, not necessarily in the sense of street surveillance, but in the sense of, placing a bug on their phone or tapping into their emails and so on and so forth. So in the UK and certain other countries, there are laws that determine that they must obtain a court order, a warrant and so on and so forth. In other countries, it's essentially up to maybe an individual. So you have to bear that in mind and consider that. So safeguards on data sharing, and the ease of access of personal data by government officials. Now, other things that you might consider that are not definite, but are pointers to the first 5 considerations, whether or not that country is a member of human rights conventions, as well as the Convention 108 data protection conventions, which will then indicate that there's a culture of respect for privacy and data protection rights, as well as whether or not there's an independent supervisory authority. So if something were to go wrong, does your organization have the opportunity to complain to a supervisory authority like the ICO? And do data subjects have the opportunity to lay complaints against you or the importing organization with an independent supervisory authority? Nigel?
Yes, so the Serbia example, going back to Serbia, what we did was at the starting point is we did a grid. We looked at UK GDPR, EU GDPR, and then Serbian data protection law. So the first tick in the box was, do they have a law which is not necessarily similar to GDPR, but has the safeguards within GDPR? And the answer was yes. So Serbia ticked that box. And then we looked at the record within Serbia of the independent regulator. So is the regulator in Serbia independent? The answer is yes. Oh, by the way, I think the maximum fine in Serbia was 17,000 euros, I think, or something like that, or the equivalent of 17,000 euros. But there again, inadequacy arrangements, if we look at adequacy arrangements, New Zealand is £10,000 or 10,000 New Zealand dollars, which is 5,000 UK pounds. So, so that's not a determinant. You don't have to worry too much about that. But the key thing is that, one, is there a law which provides safeguards for data subjects who are not based in Serbia? Answer, yes. Two, is there a law which puts data protection requirements onto organizations who operate in Serbia, who then therefore operate outside the geographical boundaries of Serbia? Answer, yes. Is there an independent supervisory authority set up? Answer, yes. Are they independent of government? Yes. Now, one of the things about the law's relevant to police and judicial authorities, what you remember is that actually GDPR is not relevant when it comes to the prevention, detection, investigation, or prosecution of crime or use by the intelligence services. So you have to make an assessment whether you think that the laws in those countries are somewhat adequate and not overbearing on that. And in Serbia, we made that assessment based upon the type of data that was actually being said. And on number five, public authorities, what we must remember about public authorities is that, excuse me, what we should remember about access is that, did Serbia have a backdoor to the information and the personal data that was being processed by our processor who were accessing UK and EU data? Answer, no, there was no backdoor. Were they a member of Convention of 108? And I've sent in the chat box a list of those people who are members and signed up to the European Council Convention 108. Serbia are. So that gave us an indication that actually that the rights and within that convention were at least a premise, a starting point for Serbian data protection law. Now, you have to be careful about signatories to the European Declaration of Human Rights, and you also have to be careful when using that this country is signed up to the United Nations Declaration on Human Rights, because if you look at the list of the United Nations declarations, you will see that the Russian Federation is signed up for that. Now, whilst I'm not making a moral judgment here, that you would be somewhat wary of some countries when you consider human rights records against other countries as well. So it is a balancing exercise, and there's no right answer, Kunbi, when it comes to making your risk assessment once you've gathered all the information. But of course, we all know Article 5.2 of GDPR says you have to demonstrate compliance. So you have to demonstrate when you get to the end of your risk assessment, you have to demonstrate that you've been through this checklist.
Thank you very much, Nigel. So here's where we have additional measures, right? Once you have determined, that the type of data, the people's data, whose it is, as well as, the country, you've passed all those stages and determined that, potentially you can't proceed with that transfer. Here's where you need to consider if you require additional measures to be implemented to be able to properly safeguard that transfer, right? Bear in mind, just for emphasis, the use of the phrase, appropriate safeguards is not to imply that once you have implemented standard data protection clauses, then your safeguards are appropriate. The responsibility lies with your organization to make sure the safeguards are appropriate enough for the kind of transfer you intend to perform. So very quickly, we have, the two categories, which is, the technical ones, which include, encryption, access controls, logging, pseudonymization, anonymization, as well as administrative ones, which requires your organization as a controller having the right to regularly audit performance by the processor, training requirements, and established an independent complaints process, as well as potentially contractual penalties. So when drafting data processing agreements for clients, for instance, at DPAS, those are part of the considerations we try to bear in mind to be able to incentivize organizations to perform up to their, required standards to protect our clients. And very quickly, I'm just going to show you one resource here, prepared by Nigel, where he, had prepared an annex to the standard data protection clauses outlining, additional obligations that the processor would be required to implement in order not to run afoul of the contract, right? So this is an example of, there's a full document, this is just an excerpt. If you feel like you could benefit from this, you could, send us an email and we'd be happy to send this to you after the webinar. But in essence, it's just a snapshot showing, in this case, retention schedules, as well as, having an IS, information security management framework and system in place. So very quickly, do you want to add something, Nigel, or next slide?
Yeah, they're most probably, this was an Annex 2 of the standard contractual clause, and there are most probably 50 points of which you would want your processor to adhere to in terms of their information security management systems in place. And in essence, you might want to certify them or get them to certify to a certain level. The client in this case, being a multinational global organization, were very keen that the processor they used for developing their software in Serbia did introduce a system such as ISO 27001, ISO 27002. So they were very keen that took place. So what you want to be able to do is quantify that once you've done your risk assessment, once you've been through all that activity, is ensure that in your standard contractual clauses that you include those additional safeguards that Kunbi has just talked about to ensure that you minimize the risk of the third parties in the country of destination having access to personal data of which they should not do.
Perfect. So here we have now the last, well, not the last, but also a very key component, which is, and the reason why this is a bit pixelated is because it's an extract from the ICO's guidance, the official guidance for considering this particular point. Now, it's important to make a distinction here because they're similar. The legal environment of the country to which you're transferring that personal data is a different point from whether or not the legal system is such that you will be able to enforce the terms in the standard data protection clauses. Those are very similar again, but quite distinct. And here, there's, on the green side, you have the positive indications. On the yellow side, you have negative indications. And essentially, they just point to whether or not you can trust that in the event that the processor was to fall short of its obligations, your organization will be in a position to, enforce it. But there's a caveat there. It's not just your organization. You have to be certain that the data subjects whose data is being processed will also have the opportunity to, if necessary, go to court, approach a supervisory authority and obtain enforcement of their rights, against both the processor and yourself if necessary, right? So, because bear in mind that the purpose of a transfer risk assessment is not to quantify the risks to your organization. Obviously they go hand in hand, but the focus is to quantify the risks to data subjects whose data is being used. So that's a very crucial point to bear in mind when evaluating the entirety of your transfer. Nigel?
Yeah. So look, one of the key elements of here is that to ensure that when you do your checklist, is that data subjects have judicial access in the country of which you are accessing or exporting data to. And so one of the extra tick list is there judicial review? Is there an opportunity to go to court to ask a judge to remedy some of the effects that are taking place? So that's a real key point. Kunbi, I'm really conscious we've only got 4 minutes and we've got a couple of questions. So how are we doing?
This is the last slide, right? But this is the last slide. The next slide is just resources. But just to answer Julia's question, Julia, the same principle apply. We've been using processor because that's the typical relationship. Most times it's a controller in the UK or in the EU transferring personal data to a service provider outside of the EU or the UK. However, if it were the case that you're transferring data to another controller, the dynamics do not change for the transfer risk assessment. They change for other aspects of data protection, but the responsibility to perform the transfer risk assessment still remains with your organization as the controller of that personal data within the EU or the UK. And you then have to assess the risks in transferring that data to the joint controller abroad. that joint controller abroad will then be subject to its own, obligations to protect that personal data and process it in accordance with the law under that country's regulations or the UK and EU's regulations, if those ones apply. So in principle, you still must have a data processing or data sharing agreement with a joint controller, which then stipulates all the things Nigel spoke about with regard to demonstrating compliance, encryption, being ISO certified, and so on and so forth. Your organization, as the primary collector and processor of that personal data, bears ultimate responsibility, and everything we've said earlier, still applies to your organization, whether it's a processor or a joint controller you intend to transfer the personal data to. Nigel, anything to add? That's the final slide.
Yeah, no, just a couple of points before we wrap up, and if there's any more questions, put them in the box. But Kunbi, if you are a EU organization, so you're sitting in the European Union and you're transferring personal data to a third country, and you haven't done a transfer risk assessment, or you haven't done an updated standard contractual clauses, you're too late. You should have done it by the end of last year in 2022. So you need to get a crack on and actually do that. Kunbi, what about UK companies? When do they have to put these arrangements in place?
Yes, so to answer Rose's question, if the processor is going to be transferring the personal data to a third country, the processor will be the one to perform the transfer risk assessment, right? Because within that dynamic, they then occupy, they are still not the controllers, but within that dynamic, they then seem to be like the controllers, while their sub-processors might be like the processors. But ultimately, the controller who has engaged that processor still retains the responsibility to supervise and ensure that the transfer risk assessments are performed. So that's why a data processing agreement is crucial. But to answer your question frontally, if it's a processor outsourcing to a sub-processor, the processor has the obligation to perform the transfer risk assessment, but the controller must ensure they supervise, audit, and review to ensure that it's performed in accordance with the law, and ideally have a copy for documentation purposes. So Amanda has asked when organizations are using popular solutions, then the answer is you must perform, first, a data processing impact assessment, 1, and 2, you must perform a transfer risk assessment. It doesn't matter whether it's a large organization or a small organization, you must perform a transfer risk assessment and evaluate factors like whether an alternative exists that wouldn't require you to transfer the data overseas, or if you can minimize the data, or the same, other considerations we had outlined earlier. The size of the organization to which you're transferring does not impact the obligation to perform one. It might impact the level of risk, but not the obligation to perform a risk assessment.
Yeah, and just picking up Amanda's really good point there, actually. Look, the obligation of the controller is to undertake the risk assessment. It's not whether, for example, we agree with the risk assessment, but it's a risk assessment. I've had a look at the risk. We're transferring low risk data. We've got the safeguards in place. Look, we're going to run with it. It doesn't stop you doing business. What it does do is just you to pause and reflect upon, is this a safe organization, a safe country to send the personal data of which I wish to process to? Undertake the risk assessment. Once you've done that risk assessment, you can constantly review it, constantly review the processor or the controller, depending on who you're dealing with, or sub-processor in the third country, and manage your risk that way. It is a risk assessment. The obligation in law is to undertake it. The obligation in law is not to be your homework marked. It's to undertake the activity, and then you make a balanced judgment based upon the risks that you've identified and the safeguards that you put in place.
Yes, thank you very much, Nigel. So it's time for us to end this. Thank you very much. We hope that you've had, you've learned a lot, and I'm going to have Nigel say the final words. But ultimately, if you have any additional questions, please send them to us via email, and we'll do our best to get to them very soon. So Nigel, do you want to just close us out?
No, thank you very much, everyone. Keep warm out there. It's not very nice, pleasant weather, but thanks for attending. And by all means, if you need Imran, yes is the answer. It normally gets put online, and you'll get a link when we've uploaded it for you. Take care. Thanks very much.
Thank you very much, everyone. Bye.